My world came crashing down the day I found a crisp, white envelope slipped under my front door with the bold letters HOA notice printed in bright red ink. I've lived in Willow Creek Estates for over 10 years, a neighborhood that was supposed to be calm, safe, and ideal for someone like me with a serious heart condition. The last thing I ever expected was to be slapped with a warning about my medical alarm system. I still remember that afternoon like it was yesterday. I was in my recliner, crocheting a blanket for my granddaughter's baby shower, when my chest began to tighten. My doctor calls these episodes arrhythmic spasms, but in my day we just said my heart was skipping beats. Whenever it happens, an alarm is triggered from my implanted device, an alert that also connects to a base unit in my living room, and from there to an emergency call center. It's loud, yes, but not ear-splitting, and it usually lasts just a few seconds. That beep has saved my life more times than I can count. I never imagined it would become a target of the HOA. I tore open the envelope to find a neatly typed letter that read, "Your frequent use of a medical alert system has caused noise disturbances, violating Willow Creek Estates bylaws, Section 8.3, disturbing the peace. You are hereby advised to either deactivate your alarms or be subject to fines." My heart pounded wildly as I read. The adrenaline surge nearly triggered another episode. Deactivate my alarms? My medical device was the reason I was still around at 67 years old. How could the Homeowners Association be so callous? My hands shook, crocheting yarn tumbling to the carpet as I read the final lines. Failure to comply within 14 days will result in a $100 fine, which will accrue monthly until the problem is resolved. My first instinct was to call our HOA president, a stern woman named Marjorie Walker, who often marched around the neighborhood in her pressed khakis and visor, checking if garbage bins were placed an inch off the approved position or if mailboxes needed repainting. She answered in her usual curt tone, as though I were intruding on her precious time. "Marjorie," I said, keeping my voice even, "this is Helen Roberts. I got a notice about my medical alarm system. There must be a misunderstanding." "I'm afraid not, Helen," she replied. "We've had complaints." "Complaints from who?" "I've lived here for years, and no one's ever said a word. This is a life-saving device." She didn't miss a beat. "It's in the rule book. Any unnecessary noise that disrupts the neighborhood is subject to regulation. If that alarm is going off at odd hours, it's not fair to other residents." At that, I swallowed my outrage. "It only goes off if I have a cardiac episode. I can't control when my heart decides to give out." "I'm sorry to hear about your health issues," she said, not sounding sorry at all. But the complaints were very clear. The call ended with Marjorie suggesting I disconnect or silence the device and find another way to manage my condition. The more I thought about that, the more furious I became. Another way to manage my condition? It's not like I chose to have a faulty heart. This alarm system was recommended by my cardiologist. It's integrated with my pacemaker and defibrillator. It's not some optional gizmo for convenience. It's literally a lifeline. I tried talking to a few neighbors, hoping I'd find out who'd complained. Most claimed ignorance, saying they rarely heard anything from my house. A couple of folks hinted that Marjorie was on the warpath about quality of life issues. Recently, she'd forced another neighbor to repaint their shutters because they were too glossy and ticketed a family for having a volleyball net in their yard. But no one admitted to specifically complaining about my alarms. 12 days went by with no resolution. I tried reaching out again to the HOA board, leaving voicemails explaining the seriousness of my condition. My calls went unanswered. So on day 14, another envelope arrived with the official notice of fines. Seething, I called my daughter, Becky, to share the news. "Mom, this is ridiculous," she said. "They can't fine you for medical necessity. You have rights under the Fair Housing Act or the Americans with Disabilities Act, something. You can't just let them bully you." I wanted to believe she was right, but I wasn't so sure. HOAs are notorious for their power to enforce bylaws. I'd heard horror stories about people being fined into oblivion over something as simple as the color of their curtains. Still, this was bigger than an aesthetic choice. This was about my heart. Despite my nerves, I decided to fight. Fines quickly reached $200 after just 2 months, each late notice tinged with a threatening undertone. If I didn't pay or remove the alarm, they'd escalate the matter further. I wasn't sure what further meant, maybe foreclosure on my home if the fines piled up. The possibility terrified me. I spent sleepless nights tangled in worry, chest pains creeping in every time I imagined losing my house. I'd raised 2 kids here, welcomed 3 grandchildren into these very rooms. This place was my sanctuary. Now the HOA wanted to turn it into a battleground. One day, after the alarm beeped during a minor episode, I found a sticker slapped onto my mailbox. Noise violation, final warning. My temper flared. They were essentially telling me I was a nuisance for being sick. The heartbreak, combined with the fury, nearly landed me in the hospital again. But that was the day I decided, no more. They wouldn't bully me into risking my life, just so a few neighbors could enjoy absolute silence. If my heart needed that alarm, then so be it. It was time to lawyer up. I've always tried to live by the motto, pick your battles, but this was one I couldn't afford to lose. My medical alarm system was non-negotiable. The problem was, I had never hired a lawyer before in my life. My late husband, Richard, and I had a modest estate plan drawn up by a family friend, but that was it. Now, I needed an expert who could stare down the HOA and protect my rights. My daughter recommended an attorney named Patricia Hayes. Patricia specialized in disability law, focusing on how it intersects with housing regulations. The first time I met her, in her cozy office lined with legal textbooks, she listened intently as I explained the situation. She nodded in all the right places, an expression of concern occasionally crossing her features. "This is potentially a violation of the Fair Housing Act," Patricia said, peering at me over her reading glasses. "The act requires reasonable accommodations for those with disabilities. An HOA can't force you to disable a medically required alarm." I sat back in my chair, relief flooding me. "So we do have a case." She gave a measured smile. "Yes, but it might not be straightforward. HOAs can be aggressive, and they'll argue the noise is disruptive to the community, particularly if multiple residents claim it goes off constantly at odd hours." Her pen tapped against her legal pad. "Are the alarms going off regularly?" "Sometimes once or twice a week," I admitted, depending on my episodes. "Most are just quick beeps, 5 seconds maybe. If it continues, I call my nurse. But it's not every day." Patricia nodded. "We can work with that. We'll argue they need to grant an exemption under medical necessity." Leaving her office, I felt lighter for the first time in months. An expert believed in my cause, and I wasn't just some stubborn old woman refusing to follow rules. This was real, and it was serious. Armed with that confidence, I sent the HOA a formal request for a reasonable accommodation, citing the Fair Housing Act. I explained my health condition, provided doctor's notes detailing the necessity of the alarm, and declared my willingness to meet them halfway, perhaps adjusting the volume if possible, or placing the base unit in a less echo-prone room. I wasn't trying to be difficult. I just wanted to live. Predictably, Marjorie and the board rejected my request. Their written response was icy and curt. "Willow Creek Estates has strict noise ordinances, and we cannot make exceptions. If you cannot comply, we recommend you seek alternative living arrangements more suited to your medical needs." They were basically telling me to move. My jaw dropped when I read that. I felt my blood pressure spike. Leave the home where I'd built a lifetime of memories? Over a 5-second alarm? Patricia immediately prepared a complaint for a preliminary mediation session. We hoped to avoid going to court. Sometimes these conflicts could be settled if both sides just sat down with a neutral mediator. But the tension with the HOA was already thick enough to slice with a knife. A letter soon arrived. The board insisted that any conversation about exceptions to the bylaw was off the table. If we wanted a solution, we'd have to remove the alarm or risk escalating fines. I remember that night vividly. I was at the dinner table, stirring a bowl of soup absently while rereading the HOA's refusal. My phone buzzed. It was Becky checking in. Normally, I try to sound optimistic, but my voice cracked with exhaustion. The stress had taken a toll. My episodes were becoming more frequent, likely fueled by anxiety. "Are you okay, Mom?" Becky asked softly. I swallowed hard, not wanting to worry her. "I'll be fine once this is settled. It's just so unfair. There has to be some justice. You can't be forced out of your home, for needing a medical alert. Let Patricia handle it. Her voice was calming, but I could hear the tension there, too. She was angry on my behalf. The next day, Patricia served the HOA with a formal notice that we were prepared to take legal action. By then, the fines had ballooned to $500, and they were threatening an additional administrative penalty of $200 for each subsequent alarm incident. It was absurd. I felt as though I was living in a dystopian novel where saving your own life was a punishable offense. That weekend, I tried to find a moment of normalcy, sitting on my porch with a cup of chamomile tea. My neighbor across the street, Mr. Benson, a retired teacher, waved and ambled over. He lowered his voice conspiratorially. "Ellen, I heard about what the HOA's doing. That's downright shameful. I have trouble with my hearing aids sometimes. Are they going to fine me next if I watch television too loud? It's madness." We chatted for a bit, and he offered to write a letter of support, confirming that he rarely heard anything from my place unless he was right next door. Maybe a handful of other neighbors would do the same, but most seemed scared to speak out. Marjorie's intimidation tactics were well known. She once slapped an elderly couple with a $300 fine for hosting their granddaughter's birthday party without prior permit. People recognized that crossing her could invite a world of hassle. Deep down, I feared that no matter how many supportive neighbors I had, the board would remain unmoved. This was personal now, for reasons I couldn't begin to understand. Maybe it was about power, about not wanting to set a precedent for others to claim medical exemptions. Or perhaps Marjorie resented me for reasons that had nothing to do with the alarm. I'd once refused to sign a petition she circulated about a new gate at the community entrance. She'd been icy toward me ever since. Still, I refused to back down. If the alarm had to beep 1,000 times, so be it. I'd rather risk their wrath than risk my life. And so, with Patricia's help, I took the next step, an official lawsuit filed in county court, accusing Willow Creek Estates HOA of violating my rights under the Fair Housing Act and the Americans with Disabilities Act. The moment the lawsuit papers were submitted, a strange cocktail of fear and resolve welled up in me. Fear, because I'd never thought I'd become embroiled in a legal battle in my golden years. Resolve, because I knew this was the path to preserving my dignity, my autonomy, and my life. If the HOA wanted a fight, I was going to give it to them. I learned that lawsuits move at a snail's pace. While waiting for the initial hearing date, life fell into a tense holding pattern. Each morning, I checked the mailbox, half dreading a new threatening letter or a stack of updated fines. Each evening, I'd watch the sunset filter through my living room blinds, wondering if I'd lose all of this because my heart wouldn't behave itself. Patricia warned me that HOAs often come armed with their own high-priced lawyers. Willow Creek Estates did not disappoint. They hired a slick law firm that specialized in homeowner litigation, presumably paid for by the monthly dues from the entire community. It felt surreal, realizing some portion of my own dues might be funding the fight against me. Finally, the day for our preliminary hearing arrived. It was a muggy Tuesday in August, and the county courthouse was bustling with people. I clutched a manila folder containing my medical records and pictures of my in-home alarm setup, my palms sweaty despite the air conditioning. Patricia stood by my side, her posture calm and confident. Opposite us, I noticed Marjorie and two board members sitting stiffly. Their lawyer, a tall man in an expensive navy suit, stared at me with an expression I can only describe as smug. The judge, a middle-aged woman with a no-nonsense demeanor, called our case. Patricia presented a succinct argument. My client, Helen Roberts, has a documented heart condition that necessitates a medical alert system. The HOA's insistence on fining her for its noise violates the Fair Housing Act, which protects individuals with disabilities by requiring reasonable accommodations. A necessary alarm for a life-threatening condition is certainly reasonable. The HOA's lawyer countered with a rehearsed statement about community cohesion, peaceful enjoyment, and the alleged frequency and volume of these alarms. He produced a stack of typed complaints from neighbors. I recognized a few names, people I barely knew. The letters described my alarm going off at all hours, calling it startling and excessively loud. My pulse quickened. Were they exaggerating, Or had I truly been such a burden? Ms. Roberts has provided no evidence that she's attempted to reduce or modify the volume of her alarms. The lawyer intoned, flipping through pages for dramatic effect. Her refusal to comply with the community's standards has created a disturbance for many residents, particularly those with small children or night shift workers. They shouldn't be forced to endure repeated blaring alarms. My hands clenched on the table. Repeated blaring alarms? A 5-second beep was hardly a rock concert. Patricia remained composed. These letters rely heavily on subjective complaints. Let's not forget that Ms. Roberts' medical device is federally mandated for her well-being. It's not a matter of mere convenience. After some back and forth, the judge suggested a brief recess. Once we reconvened, she seemed unimpressed with the HOA's insistence that they could ban medical alarms outright. I understand the need for peace in a neighborhood, the judge said, but federal law is quite clear on the need for reasonable accommodation. Unless the HOA can prove this alarm is somehow unreasonably loud or intentionally misused, their stance is questionable. To my relief, the judge ordered both sides into mediation before proceeding. This was our chance to find a middle ground without dragging the case through a long, costly trial. I felt a flicker of hope. If reason prevailed, maybe we could settle with an agreement that I'd do my best to minimize the alarm's impact while maintaining my health safeguards. However, mediation proved more difficult than I imagined. Sitting across from Marjorie in a small conference room, I tried explaining how the alarm works. She barely glanced up from her notes. Yes, well, we need quiet. It's a senior-friendly neighborhood, but that doesn't mean we can have people's medical devices blaring day and night. I nearly choked. This device isn't blaring day and night. The loudest beep is around 85 decibels for a few seconds, comparable to a passing car horn. And it's not like I have an episode every hour. She pressed her lips together. Regardless, we've had to field numerous complaints. It's become a burden on our administrative resources. Patricia interjected, which doesn't negate the legal requirement to provide an accommodation. Are you really prepared to push an elderly resident out of her home over a necessary medical device? The HOA lawyer, who was there to represent them, tried to strike a more conciliatory tone. We're open to solutions. If Ms. Roberts can switch to a silent or vibrating alarm. I cut in. That's not an option. My cardiologist insists that an audible alert is necessary in case I lose consciousness or become disoriented. Medics or nearby family members can then respond. A silent alarm doesn't help if I'm incapacitated. Marjorie's expression was stony. Then perhaps the volume can be lowered significantly, or set to only alert a monitoring service without sounding off in the house. Patricia calmly explained that my particular device needed an in-home speaker system to communicate instructions like lie down or take medication. Reducing it to a silent system was not recommended given my history of sudden episodes. We brought a letter from my doctor, which we slid across the table, but Marjorie barely glanced at it. We haggled for nearly 2 hours. By the end, it was clear the HOA didn't want to compromise. They wanted me to fold. The mediation failed. We left that room feeling like we'd run headlong into a brick wall. The judge set a trial date for 3 months later. Throughout that period, the fines continued piling up, and I continued ignoring them. The phone rang occasionally, anonymous calls where someone would breathe heavily, then hang up. I try not to let it rattle me, but it felt invasive, like a sign I was now a pariah in the neighborhood. Yet there were small bright spots. Mr. Benson dropped by with homemade brownies and kind words. Becky organized a barbecue one Sunday, inviting a few sympathetic neighbors who believed in my cause. During that gathering, my alarm actually went off one short beat, and everyone froze. Then, realizing it was just a mild arrhythmia, they relaxed. It lasted no more than 5 seconds. One neighbor said, "That's it? I've heard cell phones ring louder." Everyone nodded, shaking their heads at the absurdity of the HOA's stance. Determined to stand my ground, I spent the next months gathering every piece of evidence I could, from doctor statements to sound level readings. I wrote out a timeline of each time my alarm went off to show how infrequent these episodes truly were. Patricia prepared legal briefs and depositions. We discovered that many of the so-called complaints the HOA touted were duplicates or generalized forms with no specific details. We built a case that they were engaging in discriminatory harassment, piling on fines, and threatening me purely out of stubbornness or personal bias. When the trial date finally rolled around, I felt a mixture of dread and resolve. I'd never pictured myself in a courtroom, facing an HOA's lawyer in a legal showdown. But there I was, dressed in my best blouse, wishing my husband were still alive to hold my hand. This was it, the day we'd fight not just for my alarm, but for the right to stay in my own home. The morning of the trial, I woke before dawn. Despite the swirl of anxiety, there was a calm sense of purpose in my chest. I brewed a pot of coffee, carefully styled my hair, and took a few deep breaths. Patricia picked me up, and we drove to the courthouse in a heavy silence, both of us mentally rehearsing. Inside, the fluorescent-lit courtroom had rows of polished wooden benches, and an American flag stood near the judge's bench. The judge, an older gentleman with silver hair and a contemplative gaze, settled in, flipping through a file. He called our case, and we all rose. From the corner of my eye, I spotted Marjorie and two other HOA members, their faces tense. Their lawyers stood tall, briefcase in hand. Patricia presented our arguments with methodical precision. She explained the nature of my heart condition and my implanted device, backing it up with a statement from my cardiologist. She emphasized how the alarm was necessary and the HOA's refusal to accommodate me was a violation of fair housing law. Finally, she detailed how the constant fines and threatening letters constituted harassment, causing emotional distress and putting my health at greater risk. The HOA's lawyer went next. He tried to frame me as an uncooperative resident who refused to explore alternatives. He claimed the neighborhood had been besieged by incessant alarms, and that the HOA's actions were only aimed at protecting other residents from an unreasonable nuisance. He presented a thick file of complaints, many of which we recognized as duplicates. Nonetheless, he insisted the volume and frequency of my alarm were excessive. But I noticed the judge's brow furrow when the lawyer described me as a nuisance. The judge asked, "How many times, approximately, in a month does the alarm go off?" The lawyer consulted his notes. According to the complaints, anywhere from 2 to 6 times a week. Sometimes more. Patricia cut in smoothly. We have actual data from Ms. Roberts' device. It logs each incident. Over the last 6 months, it's gone off a grand total of 18 times, averaging 3 times a month. That's quite a discrepancy. She handed the log to the judge, who studied it with a keen eye. "Mr. Lansing," he addressed the HOA attorney, "how do you reconcile this with the HOA's claim of multiple weekly disruptions?" The attorney fidgeted. "It's possible the neighbors are overstating or mixing up what they heard. We only have their testimony." Marjorie shifted in her seat, but said nothing. I noticed her mouth tighten. Clearly, their data wasn't as airtight as they'd hoped. Next, Patricia introduced the sound level readings. She demonstrated how the beep was roughly 85 decibels, loud but not unbearably so. A normal vacuum cleaner or a hairdryer can exceed 90 decibels. "Yes, it's noticeable," Patricia admitted, "but we're talking about a 5-second alert, a handful of times each month, critical to saving Ms. Roberts' life." The HOA's lawyer tried to argue that the beep could come in the middle of the night. Patricia nodded. "Yes, it can. Medical emergencies aren't on a schedule. That's precisely why reasonable accommodations exist for these unpredictable health needs." Over the next few hours, the court heard from witnesses. Mr. Benson testified on my behalf, explaining that he lived across the street and rarely heard anything. Another neighbor, who was also an HOA board member, repeated the mantra that neighbors shouldn't be disturbed at any hour. But her testimony wavered under Patricia's questioning, revealing she had never personally heard the alarm. She'd merely seen the fines printed in monthly HOA meeting minutes. By the end of the hearing, the judge's demeanor suggested he found the HOA's stance excessive. He asked both sides if they had any final statements. Patricia succinctly reiterated our main points, and the HOA's lawyer insisted I was refusing to work with them. I clenched my teeth, frustration welling up, but I knew Patricia had represented me well. The judge leaned forward. I'll review all evidence carefully, but from where I stand, the Fair Housing Act is quite explicit. If Ms. Roberts' device is necessary for her medical condition, and it appears it is, then denying that accommodation or penalizing her for it may well be illegal discrimination. I will issue my ruling in due course. Those words were enough to ignite hope in my chest. Patricia squeezed my hand. We left the courthouse, the tension in my shoulders finally releasing. Even though we didn't have an immediate verdict, I sensed the wind was blowing in our favor. 2 weeks later, a thick envelope arrived. Inside was the judge's final decision, typed in official black lettering. I skimmed the lines and my heart soared. The HOA's fines were ruled invalid. I was under no obligation to pay them. The judge determined that Willow Creek Estates had violated my right to a reasonable accommodation under federal law. The court ordered the HOA to cease all punitive actions regarding the medical alarm and to pay me damages for emotional distress and attorney fees. My eyes widened at the amount, $8,000. It wasn't a life-changing sum, but it was a clear statement that the HOA had overstepped. They'd pay not only for my legal costs, but for the turmoil they'd caused. Reading that, I finally breathed easy. All the fear, the sleepless nights, the intimidation, it was over. Becky was ecstatic, calling to say how proud she was that I fought back. Mr. Benson popped by with a bouquet of flowers, claiming he was just out for a walk, but I knew he wanted to celebrate. I baked a pie for Patricia as a thank you, though she insisted it was all in a day's work. The aftershocks of the ruling rippled through Willow Creek Estates. Word spread that the HOA had lost. A few neighbors, ones who had sided with Marjorie, started avoiding me, their expressions awkward whenever we crossed paths. But others reached out, telling me how glad they were someone finally stood up to the board's overreach. Marjorie herself resigned a few months later, citing personal reasons. The new HOA president sent me a polite letter promising a more inclusive approach going forward. Life settled into a calmer routine. I still have my episodes, but each time the alarm beeps, I no longer panic about a fine or a neighbor's wrath. My home, with all its memories, remains mine. Best of all, I discovered a renewed sense of confidence. When push came to shove, I stood up for myself, and it paid off. And I hope my victory sends a message to anyone else who's been cowed by an HOA. You have rights, and you shouldn't be afraid to exercise them. So yes, sometimes my heart still flutters in the middle of the night, sending that life-saving beep echoing through the halls. But now, I hear that sound for what it truly is, a testament to survival, and to standing up for what's right, no matter who tries to silence you. The end.